好，大家好，欢迎来到美国北一女校友基金会 ABAP Young Professionals 我们5月的讲座。那我们我们上一次的主题是婚姻法 Family Law 基本入门的分享，很受大家的欢迎，我自己也收获良多。所以呢，有兴趣的人呢，可以上我们的 YouTube 去看上一次的录影。那我们今天就决定延续上一次的法律主题，邀请大家一起来学习基本的信托还有遗产规划。世事难料，在座不论年纪大小，想必都希望如果当自己不幸离去的时候，资产都能够得到妥善的处置。所以我们很开心能够邀请到我们的刘律师来跟大家分享。那我们今天的讲座会是英文进行，那有问题的人呢可以举手，或者是在 chat 里面，或者是留到我们最后 Q&A 的时候来和大家一起讨论那我们就废话不多说 ，Let's welcome Shannon. Welcome.
Okay. Hi. Thank you, everyone. My name is Shannon Liu Shair. Like Crystal mentioned, I'll do this in English, but if you have questions later, would like to chat in Chinese, we can certainly try that. But for the purposes of this, we'll keep it in English first. So thank you for coming. Just a little bit of background. I am a mom. I have 2 children. Madison is my daughter. She's now 9, and my son Ripley is 7. I actually live in California. I mostly grew up in the Bay Area, and I live in a town called Fremont. I went to school in the U.S., and I started my law practice in 2017. My mom actually went to 北一女. And so we are taking the kids back to Taiwan for their first time this November. My mom has a reunion, and then, we'll get to spend time with her, my dad, and visit Taiwan. So very excited to eat all the good food, to introduce the kids to all of the places that I grew up going to. Now, I know that it's important to let you know that this workshop is not technically legal advice. This is not setting up an attorney-client privilege relationship by watching or viewing this. So similar to the family law seminar that you had last time, it is vital to note that different states may have slightly different standards. So if you end up having specific questions after this, you do not live in California, I do recommend seeing an attorney in your state to see your particular situation. But a lot of this does apply to all of the US. The main thing is that there are slightly different laws with regards to family law, community property, separate property, or tax laws. So that is vital to know about. Now, when we are talking about estate planning, that means that we are talking about several different things. And like Crystal had mentioned, 遗嘱 is the will. So first, what we will do is we will talk about the different types of components or documents that people are considering when they are thinking about estate planning. So the first one is the will. This is one that most people have heard about. It's the most common. People will say, oh, do you have a will? Maybe you heard about on TV about a celebrity, they passed away, and then they'll say, did they have a will? But a will essentially is your legal document saying what your wishes are with regards to your assets, with what you would want to happen. So for instance, if you just had a will, that would say, if I pass away, I want all of my assets, my personal belongings, to go to these people. Or if you want to give it to charity, if you have people that you do not want the assets to go to, all of that can be listed in your will. The will also indicates things like who you would want to take care of your children, if you have young children under 18, as well as who do you want to be in charge of carrying out the wishes, making sure that things are being managed if you have passed away, making sure that someone is following your wishes. In terms of the will, this is called your executor. So we'll go through all the different documents first, and then we'll discuss a little bit more about what those mean. And then something that a lot of people have also probably heard about, but probably a little bit less than the will, is the living trust. So the 生前信托 The living trust essentially is an agreement that you set up during your lifetime, saying what your wishes are, that you're in control of during your lifetime. But if something has happened, what are your wishes? So I'll give an example. In California, if you are married and you hold all of your assets jointly with your spouse, then you may be setting up a trust that is joint. So a trust between you and your spouse. And if that's the case, usually that means you both are still able to make decisions, how to spend, save, and if something happens to you both, then here is who you trust to make the decisions and what the wishes are. If you are not married, or if you have significant assets that are just your own, that are not connected to a spouse, you may be setting up a trust that is your own, that you are the person who is managing. It is all of your assets in the trust. And if something happens to you, here is who is in charge as the successor trustee. So something that comes up often for people who maybe all their family is in a different country, maybe all their people who they trust are in a different country, it is vital to know that the person who you allow to make the decisions for finances, to carry out the wishes for the trust, does need to be someone who is either living in the US or is a US citizen, because if someone is managing trust assets, taking care of that, and they are not connected to the US at all, either by residency or by citizenship, then that does potentially impact your trust to have international tax issues. So I know that was a question somebody had. What if my family all live in a different country? What to do? So that is something to be aware of, because essentially a trust is designating what the wishes are, who's in charge. We need the people who are in charge to be connected to the US. But by having the trust indicates if I'm alive, I'm making the decisions. If I am incapacitated, cannot make the decisions, here is how the funds are being used for me, for my family. Or if I have passed, the trust says who are the assets going to. So it's making it as clear as possible as to who do I want to give to? Are there any restrictions, timeframes, being as specific as needed so that the trustee can manage that. And then also, when you have a trust in the US, it is very important that you are letting your financial institutions, the banks that you use, know. If you have a house, it's important that the county that you have a house with knows about the trust, because that is what allows the trust to not have to go through probate. And I'll discuss a little bit about probate in a couple of minutes. But oftentimes that is the biggest concern that people have, is making sure that if I pass away, it's very clear who is in charge and who everything goes to without having to go through the court. And a couple of more pieces of the estate plan before we talk more about probate are the power of attorney and then the advanced healthcare directive. Those are what we call our incapacity planning. So right now, it is clear you are able to make your own decisions. You knew about this seminar, you know what time it was, you know how to log on to the Zoom. So it's very obvious that you are able to manage things, able to take care of different day to day. But in the US, if it is not clear that you can make decisions, maybe something mentally debilitating has happened, then it is vital that there's authorization for who can make your decisions. So the power of attorney document, this is the legal authorization that says, if I am alive but cannot make my decisions, here is who can do that. So here is who I authorize to handle my taxes, to take care of financial transactions, make sure bills are paid. The power of attorney also would say when they can start making decisions. So is it that I require that one doctor has said that I cannot handle the decisions before someone else can act, or is there a different standard? But the goal here is to make sure that it's clear who is able to take care of my day-to-day finances so that they do not have to go through court to petition for the right to make my decisions. In the US, we have a process called conservatorship, and that is a court process where if I cannot make the decisions, it's not clear who is allowed to make them for me, that the judge has to make the final decision over who can be my conservator, who is making the decisions on my behalf. Conservatorship proceeding can take quite some time. It can be very stressful. We're trying to avoid that by having the incapacity planning. So the power of attorney document, again, that references the day-to-day finances usually. And then the healthcare directive, this is just focused on your medical wishes, the healthcare decisions that you have. So power of attorney documents, healthcare directives are common all over the US. Different states may have slightly different regulations for what these documents need to say, what they look like. So if you are getting these done, it is very important that it is based on the state that you live in. But a healthcare directive indicates who can speak to my medical team, who can make medical decisions if I'm not able to, so that the doctor knows this is who they can get in touch with and trust. It also would say, what are some of the wishes that I have? What are my thoughts on organ donation, on life support, medical treatment, making sure that those things are very clear so that the people who you trust are able to make the decisions. When we're thinking about the healthcare directive, that can be somebody, the agent who you trust can be somebody who is in the US and can be somebody who is not here. The main thing is that it has to be somebody who is at least 18 years old, who you trust to make medical decisions for you. And with all of the estate planning components, it is good to think about who is the first person you trust, and are there other people that you would trust after them as alternates. So for instance, if I put that my husband is my healthcare agent, he can make the decisions for me if I cannot. But if something has happened to him, then it may be a good idea to have other people listed just in case. That way, if something happens, my husband's too busy or something has happened to him, then I do not need to rush to change my estate planning documents right away because there are other options. And I had mentioned that we would talk a little bit about probate. And a big question that I get is about what is a will? What is a trust? Do I need to have one? Do I need to have both? So it is important to note that different states have different protocol with how probate court works. Some states may have more difficult, complicated, lengthy probates. Some may not be as troublesome. In California, where I am, probate is the biggest concern for many people because probate happens when you pass away with over $184,500 or more of assets. That's the number for this year. It does change with inflation. But if you pass away with over that number of assets and you have not done any planning, nothing has been appropriately designated, then that's when probate is necessary. So probate is a big concern because in California, at least, it can take a year, it can take longer for the judge, for the probate examiner to work together with your remaining family to determine who's in the family, who do the assets go to. During a probate process, the assets essentially are frozen. So that means if someone needs to pay bills for you or take care of something, if you've passed away and there is a probate, they cannot touch those assets. They may have to pay it out of pocket and wait until the judge has the final order saying who everything goes to until they can reimburse themselves. So if there is a probate without any level of planning, then the judge has to go based on what the law says. So that every state has its own regulations for who is considered your closest of blood relatives, who do the assets go to. So that is important to be aware of, that there is a process for that. There are standards. And when people do not want their assets to go through probate, they want it to be very clear who everything goes to, what the plan is, then that's when this question of trust versus a will becomes very important. So the will, 遗嘱, is considered a death document because it's essentially saying, these are my wishes if I pass away. So none of those wishes are happening. Nothing is occurring until I have passed away. But I am saying what I want to happen. So because a will only takes effect if I have passed away already, then it does not bypass the probate process. If you have the will and the assets go through probate, it does give guidance to the judge about what you wanted to happen, who is in charge of making sure the probate is going through. That's called your executor, and the judge can then work to determine should these wishes be granted or are there other conflicts that they need to be considering. Now, the trust is a bit different from the will. So the trust is often what we call a living document because that is something that is effective upon when you sign it, when you set it up. It is effective when you can make decisions, when you're incapacitated, and after you pass away. So because the trust starts during your lifetime, even though you can make your own decisions, even though you can change the wishes, it is living and it is already in effect when you have signed it. And with that, when you have a trust, you can connect your bank accounts, your assets, your real estate to the trust, but not with a will, because a will is not in effect yet. So when you are able to connect those assets to the trust, then that is what allows the banks to know that they have to follow the trust, and it does not have to go through probate. And I'll go over that process called funding the trust in a little bit. There are situations, though, where someone may decide, I only need a will. And that is becoming fewer and fewer nowadays, because typically that is when people do not need a probate, or that their wishes are very simple. Everything that they want to give is to an adult. Maybe they have a lot of beneficiary designations set up. They are very elderly. And so it may not be as vital for them to have a trust. But when people do have assets that are subject to probate, when they do have specific wishes, they do want to make sure that they're planning short-term, mid-term, and long-term goals, because a trust can offer contingencies, can talk about different types of scenarios. Then they would set up a trust for those wishes and also would have a will. Because in that case, the trust would dictate what happens to the assets, the accounts, the real estate, and the will would be more for dictating what happens to your non-trust items, things like cars, furniture, jewelry, things in the home, or who do you want to take care of minor children. And a big question that people have is about who needs to have estate planning? When should I get this done? Why do I want to get this done? I know that the target group for today is people who are millennials like me. So maybe you are still figuring out, what your long-term situation is. Maybe you're just getting married. Maybe you're deciding whether you want to. Maybe you have a young child, or someday you want to have a young child. Or maybe your thought is if something happens, you want to make sure that everything goes to your parents to take care of them. There are still reasons that people who are on the younger side may be deciding to do their estate planning. Sometimes people ask, is estate planning just something that I need to have if I'm a multimillionaire? And the answer really tends to be no. Like I mentioned, in California, if your assets are above $184,500 worth of assets subject to probate, that's when probate can be an issue. In other states, that number for probate can be different, but it usually is not at such a high level that people who have a house, people who have large accounts do not have to think about probate at all. And probate, again, is something that is different from state to state in terms of its complexity, the time involved, the expenses. So that is something to be aware of. But in California, probate avoidance tends to be a very big issue because people do not want their family to go through the court process. A lot of times I will see that people decide to do their estate planning when they had a family member or a friend who passed away and they had to go through probate. So my client may have seen how stressful it was, how long it took, and how it brought a lot of problems for that family. So they decide to do their estate plan, and their family would not have to go through that. I also do see a lot of clients where they knew somebody who passed away and that person did have a trust, and they were able to hear about how easy it was because the trust was done well. It was very clear what the wishes were. Everything was connected to the trust. So the family did not have to go through probate and had an easier time. And that may motivate clients to do their own estate planning. It also is a common reason to do estate planning. If you know what your wishes are, you want to make sure that is clear. For instance, if you know that you want assets to go to particular family members as opposed to the standard that the court has, if you know that you want assets to go to certain charities, or if you know that there are people who you do not want to make decisions for you, you do not want the assets to go to, that can be a very strong reason to think about your estate planning. Otherwise, if the assets go through probate without any planning, then it does have to follow the state statutes for how the funds are being distributed. And in the event that you have minor children or you have other family members or beneficiaries who are not able to manage their own funds, then a trust can be very important because the trust, you can set up regulations. Like if I pass away and my children are still young, here is how the funds are being used. Here is the age at which they can inherit the funds if I have passed. Here's who's making the decisions and how they're utilizing that. Or if you have older parents who they are not good at making the decisions, you're worried that maybe they will get into bad finances, then you may decide, if I pass and my parents are still alive, I want this person to manage these funds for them to make sure that good money decisions are being made, their needs are taken care of. And in the US, another big factor is if you have a family member or a loved one who has special needs, then it's vital that the assets do not go through probate in order to get to that person with special needs. In the US, the people with special needs sometimes are eligible for government benefits like SSI. And those government benefits are what we call income restricted or income based. That means that if the person who has the special needs has over a certain dollar amount to their name in any given month, right now that's $2,000, then their eligibility for the government benefits starts decreasing. So when we have someone that we want to give money to upon our passing, and they have those government benefits, have a special need, they cannot manage their own funds, it's vital that the trust indicates how those funds are used, who is in charge, so that it does not impact their government benefits. Something that also comes up as a question sometimes is about asset protection. This is very state specific. In California, we do not have asset protection trusts. I'll go over a little bit more about what types of trusts are typically available. But in some states, there are what are called asset protection trusts. So if people are looking to secure their assets in certain ways from liability, in different states, there may be the opportunity to do so to some level of degree. So that's another thing that people may be considering. But by and large, the big thing is trying to streamline the post-death process for family members, for loved ones, so that they know what to do. They can handle it easily with some help if they need, but not having to go through court. And in terms of the types of trusts, the ones that we usually see for the typical person who's trying to make sure their wishes are clear, does not want the assets to go through probate, and maybe does not have any other tax concerns. Usually in California, we are setting up what is called a revocable or revocable living trust. So in California, if your assets are connected to your spouse, you're married, and everything is joint, then typically you will have a joint trust. And this also applies for a lot of different states. Essentially, a joint trust means that you both are still able to make the decisions. Everything is still connected to your social security numbers. You do not need to file taxes any differently. Essentially, it is a purse that holds all the assets, making sure that everything is secured if you have passed. With a joint trust, things can be different with regards to the structure. If one spouse passes, how is the second spouse, the surviving spouse, managing things? There can be situations where the second spouse is still handling everything under their social security numbers, making all the same decisions that they need to make. But if there are estate tax concerns, if there's maybe second marriage that they were in, or a blended family, or maybe if there is a concern that the surviving spouse would be using the funds inappropriately, then people may be setting up trusts that have different structures like disclaimers, AB provisions, if the first spouse has passed. So when you're doing research on estate planning, you probably will come across the terms of AB provisions, bypass trust, disclaimer. Those are all essentially going through that scenario. If there's a married couple and one passes away, how does the surviving spouse have to handle things, have to manage the assets that are remaining? If you have your own assets, or you are not married, then you would be setting a trust by yourself. So the reason why married couples can have joint trusts is because married couples are allowed to have assets they are giving to each other. Typically speaking, otherwise you would not have a trust with somebody else. So I would not have a trust with my mom because that might be considered giving her gifts back and forth. I might have a trust just on my own if I had my own separate property. And if you have a trust on your own, then you are the person putting the funds in there. You typically are the person making decisions. But if you cannot make the decisions, then you would be appointing that successor trustee for who is handling the wishes following what you have set up. Something that is important to note, in addition, I mentioned that the trustee does have to be connected to the U.S. The trustee does have a fiduciary duty to the family, to the people who are the beneficiaries. So the trustee does have to follow the wishes, does have to make prudent financial decisions, but it's still very important that you trust whoever you have listed, whether it's a family member here, whether it's a friend, or whether you need to look into a corporate trustee or a private professional fiduciary company to act as your trustee. Those are all different options. Particularly, sometimes I do see with my clients who do not have any family, do not have people that they trust in the US to manage these decisions, they may be looking into professionals to take on that role. And I won't talk about these too much. There are also irrevocable trusts. So the revocable trust is the trust that you can make changes to over time. You're trying to avoid probate. You can change your wishes for who the assets go to, who's in charge of that. You can change the wishes for how the funds are being distributed, and you can change what the assets and the accounts are in the trust during your lifetime. As long as you can make the decisions, you have the mental ability to do so, you can make those changes for the revocable trust. There are also irrevocable trusts, which typically are set up if there is a tax reason, if there is a need to lock up the funds to not have the ability to make the changes the way you could with a living trust. Usually, these are set up if you have a large charitable intent, if you have an estate tax concern, or if you want to make sure that the funds are being used in a very specific manner. Like if there is a person with special needs, then that is when those may be set up. Those tend to be more complex. So if you do have wishes for those, it's very important that the attorney that you're working with has good experience with handling that, can give you good feedback about why you might want to set up an irrevocable trust in addition to a revocable living trust. But by and large, if people are setting up an irrevocable trust, they will have a revocable living trust first, and then the irrevocable trust would be utilized for more of the tax planning, the strategy involved. So sometimes if I get an inquiry from someone who says, I just need to set up an irrevocable trust, then that leads me to understand maybe they're doing some research online. They're not getting the full information to get what does that mean, what the full needs are. So in those situations, I have to be very clear with the clients to understand their full needs, to be able to have a good conversation so that we're all on the same page about what the goals are and what we need to set up. And I had mentioned that there are the different components to a typical estate plan. This is very common in most states in the US, but generally speaking, we do have these different components for very important reasons. The trust, we're setting that up as that agreement that you can make about what happens to your assets now, if you're incapacitated, if you pass away, so that those do not have to go through probate court. That's the biggest reason for most people, making sure that the wishes are clear, making sure that probate court is not necessary. When we're looking at the will, I call it a pour over will, because when you have a trust, usually the will pours over to be treated as a part of the trust to work together. And the will, the goal is to avoid probate for non-trust assets. Oftentimes it's to avoid full guardianship proceedings if you pass away and you have young children under the age of 18. Who do you want to take care of them? So for the will, oftentimes we are declaring there or in a separate nomination who would take care of young children. Similar to the healthcare directive, that can be someone who's in the US, can be someone who's not, but the guardian does have to be someone who is at least 18 years old, who you trust, who you think could take care of your children or make good decisions with a child. If people are nominating guardians, family members who are not in the US, it is also good to nominate somebody who is local as a temporary guardian. So in the event it takes quite some time for the guardian who is abroad to come to the US to take care of kids, to go through any processes, then there is somebody in the US who can take care of the kids, be able to sign forms for them, be able to pick them up from school. Those are some things to be considering with regards to who is in charge. And I had mentioned previously, the financial power of attorney, the healthcare directive, those are our incapacity planning tools. So we are making sure that it's very clear when somebody else can make the day-to-day finance or healthcare decisions for me, what they can make, what the wishes are, so that the court does not need to decide who can make those decisions for me through a process called conservatorship. So that's what the typical estate plan covers. I will get people who call and say, I just want to make a trust. And in those cases, I have to let them know it's very important for my practice that we are doing all of it, because even though people think the only thing I have to be worried about is probate, there could be other situations where the court gets involved if you have not done the appropriate planning. So we do want to ensure that we're considering all the different types of situations where something could come up, so that the family, the loved ones, do not have to worry about that. They can take care of what they need. And I had mentioned previously that when we have a trust, the assets need to be connected to it. I know that was a question that some people had. So the reason why funding the trust is important is that even if you have a trust, if your assets are not appropriately connected, appropriately planned for, they are still subject to probate. So for instance, in California, if I set up my trust and I do not connect the deed for my house to the trust, if something happens to me, then that is certainly subject to go through probate, because properties in California are above the probate threshold. And so it's not only important that you have a trust that is very well thought out with the wishes, with your goals for estate planning, for your particular needs, but it's important that it works by connecting everything. And what this means depends on what the assets you have in the US are. When we have bank accounts, typically that entails getting in touch with the banks, letting them know I've set up a trust. I want these personal bank accounts to be converted into trust accounts. That way the bank knows you have a trust, the trust applies to that account, and in their internal records, they have connected it. And that typically does mean providing some paperwork to the bank about the trust, signing off on some documents that confirm that you are putting the accounts into the trust. But typically with the revocable living trust, you do not need to get new checks. You do not need to get new debit cards. Your account number often stays the same. It's just that internal designation that the trust is connected. So the day-to-day for the bank is the same as before. Typically, the only way you may remember that you put it in the trust is when you get the bank statements. And instead of just saying your name and address, it would also say the name of the trust. For brokerage accounts, often that is the same thing, converting the account to be a trust account. And there are other assets that you likely have as a young professional. Retirement accounts like 401ks, IRAs, also sometimes TSPs if you work for the government, or anything that is connected to a retirement goal. Life insurance policies, those are based on beneficiary designations. So that means that during your lifetime for the retirement, you are saving up so that you can use it in the future. But if something has happened to you and there are still funds in the retirement account or in the life insurance policy, the beneficiary designation says, who do you want that to go to? Oftentimes, they'll allow you to have a primary beneficiary designation, and then if something has happened to that person, a contingent beneficiary designation. So depending on your marital status, depending on your wishes, where you're living, you may have a difference in how you decide to do the beneficiary designation, who you're giving it to. But typically, when we want it to be connected to the trust, when we have that set up, then the trust may be listed somewhere in the beneficiary designations. That would be very important that you work with your attorney if you do the estate planning to understand what's best for your situation for the beneficiary designations. And usually beneficiary designations can be done online or through paperwork. So that tends to be a little bit easier. And a question that somebody had, I'll also answer it later, is about real estate deeds. So when you own a property in the US, the deed indicates who the property belongs to, who's in charge of it. So if I have a deed and it just says that I am the only owner, that means that I own 100% of the property. And if I leave it at that, I haven't done any other planning, and I pass away, then that property does have to go through probate. So that means that it would go through that court process. It would go to who the judge determines is the closest of kin, because I have not done planning. If I have a trust, then I would be changing that deed, provided I want it to follow the trust. So the new deed would still have my name on it, but it would also have the name of the trust and be filed with the county where the home is located. So that lets the county know I am still in charge. I can still decide if I want to sell the property, if I want to keep it. But if something has happened to me, the property has to go according to my trust. My successor trustee can file paperwork with the county to take care of it. They do not have to go through probate. In the event that you have properties in more than one state, this is important to note that if you pass away without any planning, you would have probates in every state, county where those assets are located. So if you lived in California and you had a property in North Carolina as well, in Tennessee, then there would need to be probates in all 3 states if you passed away without planning. So that can be a significant concern for people who decide to have rental properties later on, to be aware of. If you have a deed and you have other co-owners on it, so say I have a deed with my husband, it says that we own our property, community property right of survivorship, then that means if I pass away, immediately my husband has the property without going through probate. But if he has passed away and there is no further planning, nothing done with the deed, then that's when it goes through probate. There are other types of ownership depending on the state that you live in, like joint tenants or tenants in common, for co-owners, that are really important to understand, to speak with the other co-owners if you are planning to do estate planning. Because some of the co-ownerships, like joint tenancy, if you put your share into the trust, it changes the joint tenancy. Joint tenancy means that everyone who's on the deed has an equal share in the property. And if one person passes, then that person who passed, their share goes equally to the remaining co-owners without having to go through probate. But in California, if I own a property in joint tenancy with other people and I put my share into my trust, because my trust is not a person, that will impact the automatic survivorship. So if I put my share into my trust and the other joint tenants keep their shares in their names and something happens to me, then my share goes according to my trust. But if something happened to the other co-owners who just left their shares in their names, then their shares would have to go through probate. But if I had not put my share into my trust, then their share would go to me and the other co-owners. So there are some complexities with real estate deeds that are very important to understand if you do have those issues. Tenants in common, another one that somebody had asked about, is something where people can have different amounts of ownership in the property, but if something happens to that person, it does not automatically go to the others. It goes through probate unless you have set up your planning. And I know that the target audience here is meant to be young adults, but something that often people will ask me if they have adult children, or maybe your parent is asking about putting you on the deed, that is something that is very, very important to speak to a real estate attorney or to an accountant, because people may think, I'm just going to put my adult child on the deed with me, as opposed to doing my estate planning, my trust. That does lead to some different tax concerns with regards to parent to child exclusions, capital gains, other issues with control. So there may be some scenarios where it does make sense And there may be situations where that is a really big mistake for the family, but it truly does depend. Before adding another family member to your deed, or before a family member adds you to their deed, it is very important to speak to a professional to understand what are the long-term impacts as opposed to just the short-term goals. And all of what I reflected about with the assets is dealing with US-based assets. A trust is a domestic agreement dealing with the US-based assets. When you have assets in a different country, that does follow that country's laws. So if you have accounts or real estate in Taiwan, it will be very important to speak to an estate attorney in Taiwan to take care of your paperwork there. If it's an account that over time you can put the money into your trust in the US, then you may not have to worry about it. But particularly if you have a house, if you have property in Taiwan, you cannot just move that over here. And if you decide to keep that, that will be important to manage and make plans for. And if people need to get in touch with me about blog posts, I'm sure that we can get the information over, but these are links to different blog posts on my website that go over things like wills or trusts, what's the difference, topics that people often ask, who to choose for the successor trustee to manage your wishes, manage finances, what to think about when choosing a guardian to take care of minor children, who to choose for healthcare decisions, as well as some other issues that can come up. Because when you're thinking about estate planning, it can be very personal since we do have to ask a lot of questions. Clients have to ask questions to make sure that we're thinking through all of the wishes, all of the needs, and that it is fit for what your particular situation is. So if you are thinking about doing your estate planning, it is important to start giving some thought to who you trust to make the decisions, what you want to happen, what are some particular concerns. And that is it for the presentation part. We can also go through some questions and answers at this time. I do have some questions that were sent over to me earlier, but if other people have questions too, we can go over that as well. So I can go through what the questions are that I have here. The first question was, who needs to set up a trust if I have designated beneficiaries and a will? Is there a monthly charge? How do you set up a trust? So beneficiaries, I had mentioned, those are often found in different types of accounts. That can be for your retirement accounts, life insurance policies. Bank accounts technically can have beneficiaries as well. And beneficiary designations, if you do not have a trust, are helpful in that they say who the assets go to. If you have a trust, then the beneficiary designation means this is what I want to happen. If this person is not here, here are the different contingencies. A beneficiary designation of just a particular person means it goes to that person or people. But if they're not there, and there is not an alternate designation, or there's not a contingency set up, then that beneficiary designation can fail, and those assets can still be subject to probate. So that's something to be aware of when having beneficiary designations. Also, another thing to note is that if you have a beneficiary designation and the person is someone with special needs, or they are a minor child, or they're not able to make the decisions on their own, if the money goes to them, then there can be issues with taxes, with eligibility for government benefits. If it's going to a minor child, then there may need to be a court process for who is managing the funds for them. So beneficiaries are not necessarily a bad thing, but it is important to note who it's going to, how you want those to be designated, because the beneficiary designation just says who it goes to. It doesn't give any other feedback or timeframes. If you are doing estate planning, a couple of questions came up about whether there is a monthly charge. And There are some attorneys who do have maintenance plans. So they may say, every year, if you decide to be a part of this maintenance plan, it costs this amount of money, and then that entitles you to do certain things with that attorney. Maintenance plans are not necessary. Some people like to have it if they need more assistance, they need more guidance. My firm personally does not do maintenance plans because I don't find that most people need that. Most people, they may not need to make changes to their estate plans for years. And so I don't find that having to that it makes sense to have them pay for something that they may not be using. And I also personally think that if people have questions, if they're opening up new accounts, they forget how to connect it to the trust. I do want clients to feel comfortable asking me without having to pay for that. So many firms will not have a maintenance plan, a monthly charge. There are some that may. There was also the question about how to set up a trust. So I think I actually might stop the slideshow and show something else because this may be helpful. So give me a minute to do that. For estate planning, firms do handle things differently, but for my firm, we have a bit of a step-by-step process to set up estate planning. So when we're working with clients, we have to have a contract. We have a questionnaire so that we know who's in the family, who are you thinking about to make the different decisions as the executor trustee, the guardian for kids, the healthcare agent. It's good for us to know who you're thinking about making those decisions. It's also really important that your attorney knows where all of the different assets and accounts are, because that way we can advise you on how to connect those to the trust, since there is some work that clients need to do to connect the assets to the trust. For my firm, we do like to have what's called a design session. So most of my clients, we do not expect them to pass away anytime soon. So we do want to think about a lot of different scenarios about their short-term, mid-term, long-term goals. Because if something changes, we want to make sure that the estate plan is considering that wish. And then when we know what all of those wishes are, we would work on writing the estate plan according to those wishes. Because there are different components to the estate plan, it does get very long. And my practice is to send drafts to clients so that they can look them over, so that we can have a session where we are discussing the drafts, making sure they understand what it says, making sure that it fits their wishes. It's also very important in my practice that we go through the steps of how to fund the trust several times, since it is that important. And with any practice, there will be the need to sign documents. So throughout the US, estate planning documents need to have wet signatures, they need to be notarized, need to be witnessed. In my office, I do like to do that in person so that clients, unless they live very far away, we can make sure that's all done correctly, make sure that is handled. So that is often, for a lot of firms, the process. A lot of firms now, you can do some of it remotely, you can do some of it in person, or you can do all of it in person. It really just depends on what makes the most sense for the clients and how the firm decides to handle things. But by and large, with a lot of firms, the process can be, 2 months. It can be longer depending on their workflow. Mine usually take about 2 months from start to finish. So if someone says, I'm going on a vacation next week, I'm having a surgery in 2 weeks, can I get this estate plan done by then? For my firm, I would say that's too short because I want to make sure this is done well. There are some firms that will do emergency planning, doing it much quicker, but that does come often at a fee because they do have to expedite. So I hope that answers the question about the process. And then I'll go back to the other slide. Another question that someone had is, what are the steps of revising the beneficiaries of an existing revocable living trust? I would say that's very important to see your attorney because we can draft amendments to make sure that it's clear how are the wishes changing. We can also ask you if there's anything else that we need to be aware of that you may not have thought of. in addition to just changing the beneficiaries, the wishes. Another person said they have a will written in Colorado. They have a few IRAs. Should that be recorded in Taiwan too? To be honest, I can't say. I don't think that Taiwan would necessarily recognize that. You could certainly try, but because it is a completely different country with different jurisdiction and laws, I don't think that that would necessarily be enforceable. And someone asked about joint tenants. For a house in California, if one owner passes away, can the other owner take over the property without going through probate? I mentioned that earlier. Yes. Joint tenancy does mean that you have the automatic survivorship to the other person. So that's very important to know. Would you want everything to go to that other person, or would you want it to connect to your trust? How about tenants in common? Will that go through probate when one owner passes away? Yes, because tenants in common does not have automatic survivorship between the co-owners. And then 2 more questions before we see what other questions people have live. If my husband and I don't have children and our closest families are not in the US, how should we go about estate planning? So the first thing is that you would really want to consider, who do you want to list as your successor trustee, executor, the person who is managing finances, if you and your husband are not able to do so? Like I mentioned, that does have to be someone who either is in the US or is a US citizen if they do not live in the US. So that's important to think about who you would trust. Or do you need to look into a corporate trustee or a private professional fiduciary to handle that? You also can give to beneficiaries who do not live in the country. It can take a little longer to get the funds over to them, but it's not illegal. It would be very important, whoever is the trustee, that they are able to locate who those family members are, how they can get in contact with them, so that they would be able to carry out the wishes and get the funds to them if something happened to you. And then the last question that I have here on my paper is, what does it look like when executing a living trust that has 3 beneficiaries and 2 houses? Do they negotiate amongst themselves who gets what, or will everything be liquidated in equal shares? So that really, really depends on how the trust is set up. Does it say everything goes equally to them? Are there specific gifts being made? Sometimes people will say this particular house goes to this person, this house goes to this person, and then the rest of the assets go to the third person. If it just says everything is equal, then there is the option to do what is called a non-pro rata distribution, which means that depending on the amount of assets that are available, if there's enough assets that one house can just go to one person and the other persons can just take the liquid assets to make that equal, there can be the ability to just put one person's name on it. And also, it doesn't mean that the houses have to be sold. They can also be rented out if no one is going to live in them in the family, and then the rental proceeds would go 3 ways. But the main thing is that it's important to know who is the trustee. So if the trustee is just one person, that is the person who has to sign off on the sale, sign off on what's going on. But the trustee does have the fiduciary duty to all the beneficiaries. So that means that they can not just decide what's best for them. They have to look at what's best for all of the people who are set to inherit. So that really will just depend on what the trust says, but those are important things to consider if you are setting up a trust, how specific you need to be, making sure that it's as clear as possible for those who need to execute. And that's all the questions from there. It looks like there's a couple of questions. Okay. There's a question in the chat. Does a trust have to pay taxes to the IRS or the Franchise Tax Board? So that is kind of a 2-tiered question. If you are setting up a revocable trust during your lifetime, that means that everything is connected to your Social Security number you're still filing taxes regularly. Your tax burden does not shift. It does not get any better. It does not get any worse. So during your lifetime, if you have that revocable trust, you do not need to change and pay taxes differently to the IRS or to the FTB. If, however, you are setting up an irrevocable trust, an irrevocable trust means that you are setting up a separate trust taxpayer ID number at the time that the trust is created. So if that's the case, then you would have to file tax returns every year. Whether there actually is a tax that needs to be paid depends on distributions, income for that trust. So it really will hinge on if there is that separate trust taxpayer ID number, whether there will be a different tax liability or a different tax procedure. All right, and I don't see if there's other questions right now.
Okay, if anyone else has questions, feel free to raise your hand. Okay.
Okay, so someone asked, what is the fee to set up a living trust? I'm not going to answer that because it really, really depends. And the last thing I want is that you get in touch with an attorney and your specific case is very different from the typical, and then they, have to give you a number that's very different from what you expected. So I will say, however, that estate planning, if you want to do it well, it is an investment of time and money because it does require you to think about the wishes, to take some time to discuss that with the attorney. So it is important that you are in a season where you feel comfortable to have those conversations to make that time for it. If it's a typical estate plan where everything is based on avoiding probate, everything is going to, the typical family members, and you have, say, one property, then that fee would be very different from if you had a very complex estate plan where you had to put in a lot of contingencies, and say you have 4 properties in different states and we have to do deeds for all of them. That can make it a different situation for what the fee entails. But the big thing I would recommend is when you're speaking with an attorney, thinking about what their process is, about what types of questions they're planning to ask you, what types of steps it goes through, and kind of developing what the priority is at that time. Because there will be people, attorneys, or, document preparers that have low fees. That does not always mean that their work product is good or bad, but that may mean that they are seeing a lot more clients and they might not have as much time to devote to each client to make sure that it's more customized. There are also firms that will charge very, very high rates. That does not necessarily mean that their product is good or bad, but it truly just depends on finding that good fit, making sure that you're able to feel comfortable with the attorney, that they have good experience, that you trust, and that you can make sure that you're going through start to finish, having a really good sense of confidence in what you're creating. Does a trustee have the right to sell or rent out the property in the trust without the approval of the beneficiaries? The trust does not specify what to do when the owner of the property passes away. Yes. Because the trustee has the sole discretion to decide how to handle the funds. Again, they do have the fiduciary duty to the beneficiaries to do what's best for them. But at the end of the day, if they are selling it, renting it out, they would have to give the proceeds accordingly to the beneficiaries based on what the trust says. But yes, the trustee does have the authority to decide whether to rent or to sell a property, if they have that option, unless it says something like, there are restrictions on selling the property, or if the beneficiaries are of a certain age and the property has to be held in trust until they're a certain age. If it does not specify, then the trustee does have that discretion. And in that case, the beneficiaries have to pay taxes if there's rental income. So if there's rental income, everything's still in the trust. That would be at the trust level, I believe. But if it is taken out of the trust and then it's just in the beneficiary's names directly, so say it's in my name and my brother's name, as opposed to in the trust name, then it would be our taxes that it's going off of. So it depends on if it still remains in trust or if it's directly already changed to the individual beneficiaries.
Okay, cool. Last call. Anyone has any questions? This is the time to either raise your hand, put your question. Otherwise, like, thank you so much, Ms. Liu. This is like really, really informative and really helpful. I'm pretty sure like everyone here learned a lot.
Thank you. And, I hope this was relatively interesting. I know this is nobody's favorite topic. The big thing that I like to tell people is you're not doing estate planning because you think something's going to happen anytime soon. It's that you just want to make sure that things are set, you're doing it well. The worst thing that happens is when people call me and they say, oh, a family member is going into hospice, or they only have so much time left. Can we do their estate planning? A lot of times that answer is no, because they do not have the mental ability to make those decisions anymore. That's often really what we're trying to avoid against. And especially, I think, with my Chinese clients, a lot of times for older clients, it's hard for them to talk about these things. So a lot of times we have to say 百年, make sure that they know we're not expecting anything to happen, but it's just being prudent and making sure it's clear what the wishes are, because you love your family, want to make it as easy as possible.
Okay, cool. Thank you so much. Thank you everyone for attending, and thank you again for Ms. Liu for your time. So let's wrap up this webinar here. Thank you, everyone. Thank you.
Thank you.